Hello and welcome to this Field Seymour Parks webinar. My name's David Clay and I'm an associate in the FSP employment team. So today's webinar is going to be on the topic of long-term sickness absence and it's titled, as you can see on the slide, Is Your Company Absence-Minded? A practical guide to dealing with long-term sickness. And this is part one of 4 parts of this webinar. So part 1, introduction, staying in touch and pay arrangements. That's what I'll be covering in a moment. You can see on the slides there's my LinkedIn address. If you enjoy listening to this webinar and you'd like to send me a message or connect on LinkedIn, that would be great. And also our Twitter handle at FSP Law. If there's anything you'd like to tweet us about, or again any comments you'd like to make via Twitter. So without further ado, I'll move on and get cracking with part 1. So just to start off with, run through an agenda. Part 1, introduction, why long-term sickness? So why is it that we've gone to trouble of preparing a presentation on this topic? What is it that you need to be thinking about as an employer dealing with long-term sickness absence scenarios? And why does this cause you a problem? So I'll chat in a minute about that. And then pay arrangements, staying in touch as well. Sometimes things that you don't necessarily think of straight away, but it's important to cover off at an early stage when you're dealing with long-term sickness. Later on in this series, so parts 2 through to 4, I'll be focusing on the later stages of dealing with sickness absence. So just to briefly talk about these, part 2, that will be focusing on investigation, obtaining medical evidence, and considering whether your employee on long-term sick leave may qualify as disabled under the Equality Act, and if so, what rights they have and what duties you have as an employer. Just moving on to part 3 then. At part 3, I'll be looking at the consultation process. So what to cover off in your consultation with an employee who's off sick, how to go about that. And I'll also run through some of the points to bear in mind from a procedural point of view. So how do you go about all this fairly, and especially if you're ultimately looking at a dismissal, what are the different points you need to cover off to make sure that you're not putting yourself in a tricky situation as an employer. Then finally, part 4, really sort of following on from what I'll be talking about in part 3 related to dismissals, just some sort of complicating factors to bear in mind before you make any decision to dismiss somebody because they're not able to perform their role. I'll run through a few common challenges as well, which various clients over the years have encountered when they've been trying to deal with these long-term sickness issues. And then finally, I'll just recap for you the contents that I've covered throughout parts 1 to 4. So let's make a start, to say, on part 1, an introductory section. I think it's going to be pretty apparent to most employers that long-term sickness absence is clearly an issue. And there are a number of reasons for that, as I've set out on this slide. So we're looking at financial implications, HR management time, the impact on colleagues of the person who's off sick, and litigation risks. So just to run through all those in a little bit more detail, starting with the financial implications as represented by my old school £1 coin photo just there. So you've got the obvious issue that what are you going to pay somebody while they're off on long-term sick leave? And really that's going to be a case of looking at the contract and handbook of your particular company to see what the arrangements are, because they'll vary. So company sick pay, statutory sick pay. Statutory sick pay, of course, is something that you've got no discretion about. If somebody's eligible for statutory sick pay, you have to pay it. But in addition to those costs, money that you're paying out to the employee, you've also got additional costs such as overtime that you might be paying your remaining staff who are having to pick up the slack for the employee who's off on long-term sick leave. Potentially, as well as that, you could have costs of someone you've brought in to do work on a temporary basis while your employee's not able to work due to sickness absence. In terms of HR and management time, clearly there'll be some input required from your HR team to keep up to date with the employee's absence. So what's the prognosis for their return? Obtaining sick notes and medical evidence, all these things eat up time. Someone's got to do it, and ultimately it's a drain on resources you'd rather not have. For the managers of the employee who's off sick, they'll need to reallocate work amongst the rest of the team. So again, that's a headache they'd probably rather not have. Looking then again at the impact on colleagues, obviously if you've got somebody off sick in your team, then unless the employer's being pretty speedy about replacing them, the work that they otherwise would have done will need to be shared amongst the rest of the team. Now, if you've got a very large team, perhaps you can accommodate somebody being off more easily, but if you're a small or medium-sized employer and somebody is off in a team of perhaps 5 or 6 people, that's going to place quite a substantial additional burden on those employees that are still in the business and fit and healthy and working. And I think it's worth bearing in mind here that while your focus is understandably going to be on the employee who's not able to work, so often long-term sick, there's a danger that those employees who are left to pick up the slack, as I say, could themselves develop their own health problems if they're not managed carefully. So if they're being required to work large amounts of overtime, they're feeling burdened by that weight of additional work. Are they going to feel stressed? Is that stress going to develop into perhaps mental health problems? So there's a risk there that actually you start off with one individual on long-term sick leave, but if it's not handled carefully, the situation can develop and leave you with additional problems. So making sure that you're looking after your staff in the same team as somebody who's off sick is another important issue for you to consider as an employer. And then the final point on this slide, this is clearly a high-risk area for litigation. Often when you've got somebody off on long-term sick leave, they will qualify as disabled under the Equality Act. Not always, but it's certainly a possibility. So with that comes the risks of uncapped awards in the Employment Tribunal for discriminatory treatment if you fail to comply with all of your duties as an employer. Even if the employee is not disabled, there are various claims that they may be able to bring, such as unfair dismissal claims, which clearly present a financial and time challenge to you as an employer. So that's the introduction really, and that's why this is such a big problem for employers, and why we feel it's worth looking into in more detail what you can actually do in practice to handle these issues and leave yourself in the best position possible. So moving on then to the next slide, staying in touch. So you might think, well, this is pretty obvious. Clearly I need to stay in touch with my employee who's absent on sick leave, but I think on occasions when someone's out of the office, out of the workplace, they're out of sight and they're out of mind as well. And it's quite easy to let these situations drift on, and suddenly a few weeks or even months have passed where nobody's really made a concerted effort to stay in touch with this employee, find out what their problems are and what you as an employer can do to help. So establishing contact with the employee and setting expectations around the level of that contact is a really important first step in managing sickness absence, particularly where it's gone beyond a few days and we're now looking at a long-term absence. So the level of contact is going to vary from case to case. It's going to depend on the nature of the employee's illness. It's going to depend on their seniority to some extent within the business. How crucial are they? Do you really need to be contacting them? Or are they doing a relatively straightforward role which is pretty easy to pick up without any sort of handover or detailed discussion? So that's a key point, making contact at an early stage with your employee. You also need to make sure that you've got an update from your employee as to what it is that's actually keeping them out of work. And the first piece of medical evidence that you're likely to get hold of on that point of view is a GP's statement of fitness for work. And that's something which you can require an employee to provide to you after they have been absent from work for more than 7 days. Up until that point, generally it'll just be self-certification of sickness, but clearly we're looking at long-term sickness absence. Once it's gone beyond 7 days, you need to be asking your employee politely to provide you with these statements of fitness for work, and that gives you the first clue as to what the issue is, what the health issue is that's causing their absence. Now, it's a difficult balance to strike sometimes when you're thinking, well, how much contact do I actually need to make? How often should I be getting in touch with the employee? What's too much? What's too little? There is a risk, particularly if somebody's off with a sort of anxiety, depression, other mental health related condition, that if you're constantly ringing them up and badgering them for updates, that you run the risk of making their health situation worse and also potentially giving them a claim against you, perhaps a harassment claim. So it's vital that you don't overstep the line, but at the same time you really mustn't let the situation drift. And this is what unfortunately we do see quite a lot of the time, is that these conversations are difficult for employers to have, and therefore the easy option is just to avoid having them. But clearly that doesn't really help you in the long term, and just makes it more difficult then to deal with these issues properly in due course. I would recommend, depending on the resources that you've got within your business, assigning one contact person to the employee who's off sick, because then that way you avoid the situation where you've got multiple people trying to get in touch with the employee, find out what's going on, potentially giving contradictory messages to the employee, which is clearly unhelpful. Whereas if you've got one individual who's handling all of the contact with the employee, then you can minimise some of those risks to a certain extent. And finally, on this slide, I would be very careful to keep a comprehensive record of the correspondence that has been going backwards and forwards with the employee. And this is important because in the event that issues arise further down the line, perhaps the employee brings a claim against you in the employment tribunal, you will be able to demonstrate to a tribunal that you have handled the situation appropriately and reasonably, and that you've made efforts from the outset to liaise and communicate with the employee to find out what the issues are. So it all goes towards demonstrating that you have followed a fair process. Pay arrangements, that's the next slide. This, as I said in the introduction, is going to vary from case to case. Some businesses will provide an employee with company sick pay for a certain period of time, and again, the amount of company sick pay will just depend on what you've got in your contracts or policies dealing with pay for periods of sickness absence. So some of our clients will have very generous company sick pay provision, potentially 6 months or even longer at full pay, followed by a further lengthy period at half pay perhaps, whereas other of our clients won't actually provide any company sick pay at all, and they're within their rights to do so. It's really just a case of what your company's policy is, and you will, generally speaking, find that very large national or multinational employers are going to have more generous sick pay, company sick pay allowances than smaller employers. Not always, but as I say, the key point really is just to check the employee's contract of employment and the staff handbook for the business, so that you understand at an early stage what an employee is entitled to while they're off work. Keeping the employee updated on their entitlements is very important, because if somebody's off sick, naturally they're going to be worried about the level of money that's coming in. And if you are working for a business that provides company sick pay and the employee is thinking, well, this is quite good, I'm on company sick pay here, at least I don't have to worry about my income for a little while, and then suddenly that income vanishes because they have exhausted their entitlement to company sick pay, and you as an employer don't tell them about that, that's going to be a bit of a nasty shock for them. So purely from a practical point of view, in terms of maintaining as good a relationship as you can with the employee while they're off sick, letting them know particularly when their company sick pay entitlement is due to expire is strongly recommended, so the employee can make arrangements for a reduced level of income. Statutory sick pay, so regardless of whether or not your business provides company sick pay, employees, provided they meet the relevant eligibility criteria, will be entitled to receive statutory sick pay. Now, it doesn't go very far. It's currently the princely sum of £92.05 a week. So that figure is accurate up until April 2019, when it will change and likely go up a little bit. But we're not talking about a great deal of money. You used to be able to recover a proportion of your SSP costs as an employer, but the situation has now changed. So this is a cost that you have to bear, but hopefully it's at a level which won't break the bank for most employers, only £92 a week. It's payable for up to 28 weeks or until you have linked periods of incapacity for work lasting for 3 years. The rules surrounding statutory sick pay are quite complex when you drill down into the detail. I don't propose to bore you with those details too much in this presentation, but what I would say on SSP is that generally the sums that you're talking about, the sums that are involved, are disproportionate to the complexity of some of the issues around SSP eligibility. So it's something that we're happy to provide advice on, but sometimes it's just worth taking a practical view rather than sweating too much about whether someone's entitled to another 50 quid, 90 quid here or there. One thing that's worth noting about statutory sick pay is that although the general position is that somebody has an entitlement for 28 weeks and once that's exhausted, there's no more SSP payable. If somebody is off for 28 weeks, but then returns to work for more than 8 weeks, their SSP entitlement is actually reset at that point. So they essentially get a fresh bundle of 28 weeks SSP. So important to bear that in mind. If you have someone who's been off for a while, exhausted their SSP, and then they come back, you will potentially have to start paying SSP all over again. Continuation of benefits, really the point to think about here is what does it say in the contract of employment. That's going to govern the position with regards to most benefits. There are certain benefits like permanent health insurance, which I'll talk about a little more in part 4, and also private medical insurance, where it would be perverse for those benefits to fall away in the event of long-term sickness absence, because the whole point of them is that they offer protection to somebody who's not fit for work. With other benefits, as I say, it's a case of reviewing the contract, potentially reviewing the handbook, but you do need to exercise a little bit of caution if you're withdrawing benefits from somebody because they are absent on long-term sick leave. If that employee qualifies as disabled, then that could give rise to certain claims under the Equality Act, or arguably it could breach the implied term of trust and confidence that exists in every contract of employment between an employer and an employee. The final point on this slide is holiday accrual, and there's a bit of tension in the legislation in this area between the Working Time Regulations 98, that's the UK legislation, and the EU Working Time Directive. They don't quite match up, but where we've got to with the case law is that essentially we have to interpret the Working Time Regulations in line with the Working Time Directive, so that EU case law takes precedence, and the situation is that holiday accrual continues during a period of sick leave, and as an employer you don't have the ability to compel somebody to take a holiday during a period of sick leave, although if they request to do so, you can permit them to take holiday while they're off on sick. If that holiday isn't taken, then it will carry over to the next holiday year until they have an opportunity to take it. So that brings us to the end of part 1 of this webinar. The parts that follow, part 2, 3 and 4, there are details of those on the slide in front of you. If you've got any queries about part 1, feel free to contact me, and my direct dial phone number and email address are on the slide. And just a final caveat that, of course, this is a general piece of advice. If you've got queries on a specific scenario, then do feel free to contact us at Field Seymour Parks, and we can advise you on the specific situation that you're dealing with.